What does it mean to own land that someone else already owns? In 1881, 500,000 families in the American West were about to find out that the answer was not as much as they thought. The document in your hand could be a government patent, signed and stamped by the United States Land Office, bearing the seal of a federal bureaucracy that had spent decades promising ordinary people a stake in the continent. And it might still mean nothing, not because the document was forged, not because the family had failed to meet the terms of the Homestead Act, not because of any fraud they had committed. The document could be entirely real, entirely legal, and still be worth less than the paper it was printed on because somewhere in Washington, years before your family arrived, someone had already given your land to a railroad company. Not your particular quarter section, necessarily. The railroad had been given alternating sections across a corridor stretching 40 miles on either side of the tracks, a patchwork of ownership that looked orderly on a map drawn in an office in the Capitol and looked like a catastrophe on the ground, where actual families had dug actual wells, built actual barns, buried actual children. Ruth Calloway knew this. She had known it for a long time, in the way that people who live close to a problem understand it, without needing anyone to explain it to them. She was 28 years old in the autumn of 1881, and she was the acting sheriff of Redstone, Kansas, a railroad junction town of roughly 400 people seated at the intersection of two rail lines that the Atchison, Topeka, and Santa Fe had laid through the flat heart of the county 3 years earlier. Her father, James Calloway, had been the marshal here for 11 years. He was a careful man, not an especially gentle one, but fair in the way that frontier laws sometimes managed to be fair when the person holding the badge cared more about the community than about the authority the badge represented. He died in the winter of 1880 to 1881, in a December that came early and hard, the kind of pneumonia that settles into the chest before anyone thinks to be alarmed and then does not leave. Ruth had been his deputy for 4 of those 11 years. The town council, faced with no obvious alternative, and a calendar full of problems that did not wait for anyone to grieve properly, appointed her acting sheriff in January. She kept his badge. She did not wear it on her chest. She kept it in the right pocket of her coat, a heavy wool coat that had been her father's too, cut for a man broader across the shoulders than she was, worn at the elbows in the specific way that working clothes wear when the person wearing them has spent years leaning over desks and fence rails and wagon boards. When she needed to think through something complicated, she would reach into that pocket and press the edge of the badge between her thumb and the pad of her forefinger. Not looking at it, not taking it out, just holding the weight of it. She said more than once that she was saving it for when she figured out what it actually stood for. In October of 1881, there was a complaint on her desk. A family named Weston, farmers who had homesteaded 40 miles northwest of Redstone along the Smoky Hill River, had received a notice from the Atchison, Topeka, and Santa Fe Railroad, informing them that their 160-acre parcel was in conflict with a land grant issued to the railroad under the Pacific Railway Act of 1864, and that they were expected to either purchase the land from the railroad at the rate of $4 per acre or vacate within 60 days. The Westons had a federal homestead patent. They had built a house and a barn and a root cellar and had farmed that land for 6 years. They had children born there. The notice from the railroad did not mention any of this. It did not need to. The Pacific Railway Act was federal law, and the grant it had created predated the Weston family's patent by years, even though the Westons had arrived before a single rail had been laid anywhere near their parcel, even though no railroad agent had ever come to survey the land until the tracks were finished and the company turned its attention to what it owned on paper. Ruth read the notice. She read the homestead patent the Westons had brought with them. She read the relevant sections of the Pacific Railway Act of 1864, which she kept in a slim volume of federal land statutes that her father had ordered from a legal press in Topeka. Then she put all 3 documents down on her desk, looked out the window at the flat Kansas sky going gray in the early evening, and reached into her coat pocket. To understand what Ruth Calloway was holding in her hand, not the badge, but the problem, you have to understand what the Pacific Railway Acts actually did. Congress passed the first act in 1862 and amended it significantly in 1864. The stated purpose was to connect the continent by rail, to bind California to the Union in the years of the Civil War, to open the interior to commerce, to project American economic power across the whole width of the country. These were not cynical goals. Exactly. The railroad was transformative technology, and the men who built it changed the continent in ways that were real and lasting. But transformation requires material, and the material the federal government provided was land. Specifically, alternating sections of the public domain in a corridor running 10 to 40 miles on either side of the right-of-way, depending on the act and the railroad in question. One section for the railroad, one section retained by the government, in a checkerboard pattern that extended for hundreds of miles. Here is where policy stops being an abstraction and starts being your family's land. The Pacific Railway Acts of 1862 and 1864 transferred 174 million acres of land to railroad companies. To understand what that number means, to hold it in your mind rather than let it slide past as an abstraction, consider this. 174 million acres is larger than the combined area of Pennsylvania, New York, Ohio, Virginia, and Indiana. The entire state of Texas, the largest state in the contiguous Union, covers roughly 172 million acres. Congress transferred the equivalent of Texas, plus the population center of the northeastern seaboard, to private railroad corporations in less than 3 years, in 2 acts of legislation that most Americans have never read and that most history books mention only in passing. The largest corporate land transfer in American history happened in wartime, in a hurry, with a logic that prioritized the infrastructure over every human complication that would follow. What came next was the complication the acts were never designed to solve, and the complications followed. They followed everywhere the rails went. They followed into Kansas, into Nebraska, into Texas and California and Colorado, into every state and territory where a railroad company had been promised a corridor of alternating sections and had not yet gotten around to sorting out who was already living on those sections. The people already living there were, variously, native peoples whose relationship to the land long predated any American legal framework, Mexican landholders whose property rights under Spanish and then Mexican land grants technically predated American sovereignty over those territories, and settlers, Anglo-American, German, Swedish, Norwegian, Czech, African-American, who had come west under the promise of the Homestead Act of 1862, who had filed their claims at the local land office, paid their fees, built their improvements, and received their patents. These were not squatters. They had done everything the law asked. The land office clerk had taken their money. The government had stamped their papers. And none of it mattered, because in a federal court, a railroad land grant was a federal instrument, and a homestead patent was a federal instrument of lower standing. And when the two conflicted, the courts had a strong and consistent tendency to find in favor of the entity with the most lawyers. The women who could file homestead claims independently, and after 1868 they could, if they were single, widowed, or the head of a household, faced a particular vulnerability in these disputes. They had less political recourse. They could not vote. They could not sit on juries. They could not threaten to throw a county commissioner out of office. When a woman walked into a federal courthouse to contest a railroad's claim to her land, she walked in as a legal person with documented rights and walked out, more often than not, with a ruling she could not appeal and no mechanism to force anyone to reconsider. The railroad's attorneys were paid. The railroad's attorneys came back next week. The woman who had farmed the contested parcel for 9 years had, perhaps, 30 days to figure out where to go. Della Morse knew this with a precision that had no abstraction in it at all. She was 35 years old in the fall of 1881, a compact woman with hands roughened to the texture of harness leather and a way of going very still when she was angry that the people who knew her had learned to read as a warning. Her family, herself, her mother, her 2 younger brothers, had homesteaded 320 acres in Barton County in 1870. They had chosen the land carefully, a parcel along a creek tributary with good drainage and soil that darkened richly when you turned it. They had cleared it and planted it and built on it. They had buried her father there in 1874, 4 years in, when a horse kicked him and the wound went septic before anyone could do anything about it. They had kept going after that, because the land was what they had, and going back east was not something her mother was going to do. In 1879, the Atchison, Topeka, and Santa Fe Railroad filed a claim against the Morse parcel under the Pacific Railway Act of 1864. The claim argued that the parcel fell within the railroad's land grant corridor and that the homestead patent the Morses held was subordinate to the railroad's federal grant. Della hired an attorney in Great Bend, which cost money the family did not have in abundance. The litigation ran for 14 months. At the end of it, in early 1880, the court ruled for the railroad. The Morse family had 30 days to vacate land they had farmed for 9 years, land where Della's father was buried, land her mother had chosen and planted and tended through 4 Kansas winters and 1 drought year that had nearly broken them. They had 30 days. They left in 23 because staying the last week felt like being made to watch. What do you do after that? You could rebuild, find another parcel, start over, try to believe the promise the government had made you once could be made again. Some families did this. Della's mother did it. She moved to a sister's house in Salina, eventually, but Della stayed in the county. She took a room in Redstone and found work wherever she could find it, and she thought about what had happened to her family's land for a long time, the way you think about something when thinking is all you're left with. She thought about the survey markers that the railroad's crews planted in the ground along the Grant Corridor, small wooden stakes, sometimes painted, sometimes with tin markers, the physical evidence of the legal claim that had displaced her family. She thought about how easy those markers would be to move. She was not alone in thinking this. The other women she approached, she was careful. She knew which families had lost land and which had not. She knew who carried the particular kind of anger that comes from dispossession rather than ordinary hardship, came from families who had all been through variations of the same process. Clara Yount, 22, whose widowed mother had lost 160 acres to the same railroad in 1878. Bess Harker, 41, who had homesteaded her own parcel as a widow in 1875 and had been fighting a conflicting railroad claim through the courts for 2 years with diminishing confidence. 2 others whose names the record is uncertain about, referred to in one surviving document only by initials. They were not a gang in any sense the word usually carries. They were a set of women who had run out of legal options and had started to think about what was left. What was left, they decided, was disruption, not violence. This was not a decision born of principle alone, though principle was part of it. They understood clearly that the moment anyone was hurt, they stopped being people with a grievance and became criminals, and the railroad had lawyers who could do a great deal with that transformation. It was also a decision born of practical intelligence. They had no guns they were willing to use against other people. They had no political allies, no newspapers that would take their side, no federal officials who were not already in the railroad's correspondence. What they had was local knowledge, the kind that comes from living in a place for years, and a specific grievance that expressed itself in specific targets. They began with the survey markers. On 3 separate occasions in the spring and early summer of 1881, railroad survey crews arriving to complete their measurements of the Grant Corridor found that their previous work had been disrupted. Markers moved, sometimes by a few feet, sometimes by several hundred yards, enough to require the entire survey of a section to be redone. The crews could not understand how it was happening. The disruptions occurred at night, or on days when no one had been near the area, and whoever was responsible left no obvious trace. In a county where every adult knew every other adult by face, the bandanas the women wore when they worked were not romantic theater. They were the difference between anonymity and immediate recognition. Ruth Calloway knew who they were. She was nearly certain of it by the time the railroad's first formal complaint landed on her desk in July, a letter addressed to the sheriff's office of Redstone Township, requesting that she investigate the survey disruptions and identify the responsible parties. She read the letter twice. She filed it. She did not begin an investigation. She told herself she was waiting for more evidence. This was not entirely untrue. The particular cold of a Kansas November is not like cold elsewhere. It comes up through the ground before it comes down from the sky, the earth itself going hard first, so that when you walk across a field in the early morning, you hear your own footsteps ring slightly, a short hollow sound against frozen soil, the way nothing sounds in warmer months. Ruth Calloway walked across the Redstone Town Square on a morning like that, her coat pulled close, her right hand in her pocket, and thought about what she knew and what she could prove, and whether those two things were going to stay separate for much longer. Della Morse was planning something larger. The railroad survey operation for the disputed parcels along the Smoky Hill corridor had established a staging area 12 miles north of Redstone, a fenced enclosure where the company kept its horses, its survey wagons, and the equipment that the crews needed to complete the final measurements of the Grant corridor. Completing those measurements was the last procedural step before the railroad could formally register its claims against several families who were still, technically, in possession of their land. The survey had been delayed once already by the disruptions to the markers. The railroad had sent additional workers. The operation was supposed to resume in the second week of November. The night before it was scheduled to resume, the fence on the south side of the staging area was opened, and the railroad company's horses, 14 of them, all well-fed animals that had no particular reason to stay in a cold field when they didn't have to, walked out into the dark Kansas night and scattered across 3 miles of open grassland. Finding them, recapturing them, transporting them back to the staging area, and determining that none of them were injured took 6 days. The survey was delayed by 6 days. 3 families who had been facing imminent formal eviction proceedings had 6 additional days on land that was no longer legally theirs. Time to negotiate, to move, to write letters that would go unanswered, to say whatever needed to be said in the houses they had built. No one saw who opened the fence. The sound of hooves on hard ground fades quickly in the dark. By the time anyone noticed, there was nothing to notice but an empty corral and a cold wind coming down from the north. The railroad's response was not long in arriving. It came in the form of 2 men from the Pinkerton National Detective Agency, who reached Redstone on a Thursday morning in late November with a sealed envelope addressed to Acting Sheriff Ruth Calloway. Inside the envelope was a formal eviction order for 3 families. The Westons, a family named Gruber, who held 240 acres 2 miles east of the Weston parcel, and a widow named Agnes Pratt, who had been fighting a conflicting railroad claim for 3 years. The order directed the sheriff's office to assist in the eviction process, which the railroad's attorneys had defined as ensuring the family's compliance with the court's ruling and accompanying the railroad's agents to each property to prevent any interference. Ruth read the paperwork for 40 minutes at her desk. The Pinkerton men waited in the outer room. She could hear them shifting in their chairs, the creak of wood, the occasional murmur of quiet conversation. She read every page, every citation, every procedural notation. She was looking for something, and she found it. A defect in the filing date, a discrepancy between the date on the court's order and the date recorded by the filing clerk, small enough that a judge might dismiss it as clerical error, significant enough that a careful attorney could argue it voided the document. Ruth was not an attorney, but she had read enough law to know what she was looking at. She walked into the outer room and told the Pinkerton men, in a voice that carried no particular emotion, that there was a defect in the filing date on page 3 of the eviction order, and that she was not in a position to assist with enforcement of a procedurally defective document. They would need to return to the court, have the paperwork corrected, and refile. She handed the envelope back to the taller of the 2 men, turned around, and went back to her desk. That bought 3 families 11 more days on land that was no longer legally theirs. 11 days is not very much, but it is not nothing. There are things that can be done in 11 days that cannot be done in 0 days, and the families knew the difference. The Muscle Slough tragedy had happened 18 months before this, on the other side of the continent. But Ruth knew about it. Everyone in the counties along the railroad corridors knew about it, in the way that news of a disaster travels not through newspapers alone, but through the specific channels of people who have a stake in what the disaster means. In May of 1880, in the San Joaquin Valley of California, a confrontation between settlers and railroad agents sent to evict them under a Southern Pacific land grant claim ended in gunfire. 7 men were killed. The accounts of exactly how the shooting started were disputed then and remain disputed now. What was not disputed was the aftermath. The railroad kept the land. The settlers who had not been killed were arrested. Several were tried and convicted. The judge, in his sentencing remarks, called it an unfortunate dispute. The Southern Pacific had been nicknamed the Octopus for years by the time of Muscle Slough, a name that captured something real about the way the company extended its reach through legal, political, and economic channels until it touched everything in the state. Frank Norris would write a novel about it 20 years later, documenting with the precision of a journalist the actual mechanics of how the railroad's land monopoly worked in California. The novel was called The Octopus. It sold widely. The land did not come back. What Muscle Slough demonstrated, what it demonstrated with a clarity that required no interpretation, was that the legal system had not failed. People who say the law failed the settlers at Muscle Slough are misreading what happened. The law worked exactly as it was designed to work. The railroad's grant was federal. The court's ruling was consistent with established precedent. The Pinkerton agents and the railroad's own marshals were acting under lawful authority. The settlers who resisted were, by every legal definition available, in the wrong. 7 of them died for being in the wrong. The judge said it was unfortunate. This is the thing that Ruth Calloway turned over in her mind on cold mornings with her hand in her coat pocket. Not that the law had betrayed her, but that the law had not. The law she was sworn to enforce was coherent, consistent, and producing outcomes that she could not reconcile with any principle she believed in. She had been appointed to uphold a system that had, by design, already decided who the land belonged to. The families filing complaints in her office were not seeking justice from a broken system. They were seeking relief from a system that was working. In the weeks following the horse release, the tension in Redstone changed quality. The Pinkerton men had returned to the railroad's regional office in Topeka, filed their reports, and the railroad had responded by escalating its correspondence with the town council. 2 of Redstone's 5 council members, a merchant named Aldcroft and a banker named Poole, held accounts and interests tied to the railroad's expansion, and they had, in the month since Ruth's appointment, been quietly uncomfortable with what they perceived as her insufficient commitment to keeping the business climate stable. The horse release gave them something concrete to point to. The defective filing objection gave them something else. By December, the council was meeting without Ruth present. She knew this because the council clerk, a young man named Hughes, who owed her a small debt of the kind that creates loyalty, told her. The meetings were not formally called. They happened after hours, in Aldcroft's store. What was decided in those meetings became clear in the second week of December, when Ruth received a formal letter from the council informing her that her appointment as acting sheriff was terminated effective at the end of the month and that the position would be filled by a permanent appointee in January. The letter cited a need for experienced leadership during a period of increased activity along the rail corridor. It did not cite the Pinkerton complaint. It did not need to. Ruth read the letter once, folded it, and put it in the same drawer where she kept the complaint about the survey disruptions and the railroad's eviction orders, and the copy of the Pacific Railway Act she had been reading and rereading for months. Then she reached into her coat pocket and held the badge for a long time without taking it out. If this story has stayed with you, share it with someone who believes the Homestead era was purely a story of individual freedom and rugged self-determination. Not to start an argument, just to complicate the picture. Because the question the women of Redstone were actually living inside, what do you do when the law is working and the law is wrong, is not a question that goes away when the era that produced it ends. Della Morse and Clara Yount were arrested in the 3rd week of December, not for anything connected to the survey disruptions or the horse release. The railroad had not been able to establish a provable connection between those events and any named individual, but on a vagrancy charge. The vagrancy statute in Kansas at the time was broad enough to be applied to almost anyone who did not have a fixed employer of record, and both women who had been working informal labor in and around Redstone since losing their land met the technical definition. The charge carried a fine and, at the discretion of the arresting officer, a period of confinement. The arresting officer was the deputy the council had quietly arranged to have standing by. Ruth was not the one who arrested them. She was no longer acting sheriff by the time the arrest was processed, having been formally removed 4 days earlier. She was present in the town, and she knew what had happened, and there was nothing she could do about it that existed within any legal framework she could reach. Della and Clara paid the fine. Bess Harker collected it from people in the county who understood what the charge actually was, and were released after 3 days. Nothing had been proven. Nothing needed to be proven. The law that had been used against them was not a law designed to address what they had actually done. It was a law that existed to address what they were: women without property, without employer, without political standing, in a county where the railroad had made its preferences known. The Weston family left their parcel in January after the corrected eviction order arrived, and there was no further procedural defect Ruth could identify, because Ruth was no longer in a position to identify anything. The Gruber family had left in December. Agnes Pratt held out until February, when the county sheriff, Ruth's replacement, a man named Donaldson who had been recommended to the council by the railroad's regional superintendent, arrived with 2 deputies and a copy of the order. Agnes Pratt was 61 years old. She had homesteaded that land as a widow. She loaded what she could onto a wagon and drove away without speaking to any of the men who had come to enforce the law against her. Whatever she said later, in private, where no record could be made of it. The railroad kept all 3 parcels. They were incorporated into the Grant Corridor, surveyed, recorded, and eventually sold, not to settlers, but to land speculators who understood how to work within the system the railroad had created. The survey markers that had been moved 3 times were replanted in concrete. The staging area north of town was enclosed with a new fence, stronger than the one that had been opened in November. By 1882, the Atchison, Topeka, and Santa Fe's holdings in Kansas, Nebraska, and Texas combined amounted to more than the area of Pennsylvania and New York together. This was not exceptional. Every major railroad operating in the American West was accumulating land at a comparable scale. The Southern Pacific had become the largest private landowner in California history. The Texas and Pacific, the Union Pacific, the Northern Pacific, each of them held more acreage than most American states would ever contain. They had not stolen it, exactly, in the legal sense that the word theft requires. They had been given it by Congress in acts that were passed with full deliberation and signed by presidents who understood what they were signing. The distinction between gift and seizure, when the recipient is powerful enough and the original occupants are not, is thinner than the paper a land deed is printed on. If you have ever held a homestead patent, a real one, folded and refolded until the paper has gone soft at the creases, the government seal pressed into it, the ink faded from handling, but still legible. You know it feels like a promise. It feels like the weight of something permanent. The families who carried those patents west, who planted them in the soil of their claims the way they planted seed, believed in what they were holding. The Pacific Railway Acts did not make that belief wrong. They made it insufficient. Ruth Calloway left Redstone in March of 1882. She settled in a smaller county to the west, took work wherever it was available, and eventually found a position helping administer a small land office in a town that the railroad had not yet reached. She was good at the work. She understood the documents. She knew the places where the law bent before it broke, and she was careful about what she told people who came in with conflicting claims. She never wore a badge again. Whether she ever took her father's badge out of her coat pocket and looked at it, no one recorded. Della Morse rebuilt. It took years, and it did not look like what she had lost, because nothing built after a loss looks exactly like what preceded it. She worked, saved, eventually purchased a smaller parcel, 40 acres in a different county outside the railroad's primary Grant Corridor. She farmed it. She was still farming it in the early 1890s, according to a county tax record that recorded her name and her acreage without any annotation about what she had done to deserve to still be standing on a piece of ground that was actually, legally, verifiably hers. What the bandana women accomplished was not what they set out to accomplish. They had set out to resist a specific injustice, to hold a specific line, to buy time and complicate the mechanics of dispossession. They succeeded at that, partially, for a while. They did not stop the railroad. No individual act of resistance stopped the railroad, because the railroad was not an individual. It was a legal instrument backed by federal authority and capitalized in amounts that no collection of Kansas farm women could match and that no sheriff with a badge in her coat pocket could outlaw. The women who rode with Della Morse did not consider themselves outlaws. They considered themselves plaintiffs, the kind the courts refused to hear. The land grants era closed, eventually. The federal government stopped issuing railroad grants in the 1880s as the political backlash built and the scale of what had been transferred became impossible to defend publicly. But the land was not returned, it was sold.